I'm going to cover 10 things companies in Tennessee can consider to do to protect their confidential information. First, determine what information is important to your business and determine if that information is in fact secret, so that you only have it, or if it's readily available to your competitors. Tennessee has a very employer-friendly version of the Uniform Trade Secrets Act, and its definitions of what can constitute trade secrets. It includes information that you have compiled as a company, so that the compilation itself can be a trade secret, even if the information, some or all the information in the compilation could exist out in the public domain. If your compilation is not readily available, it can still be protected. 2, limit access to the important data in terms of having it password protected or other access type of protections. Number 3, limit access to important confidential data in terms of who can access it. So not only should it be password protected, but not everyone needs access to the information to do their job. Have rules on where your data can reside. So hopefully the data will reside on your computers, your network, your database, and your email. But sometimes that's not feasible. And that may be even more so today when so many people work remotely or at home. And so if so, then you have to deal with that. So the problems increase with as the data gets outside kind of your systems. Number 5, have policies explaining how you expect your data to be protected and used, and then have people sign off on those policies. So this way people know what's expected of them, and you can explain to them what's confidential, what's protected, and your expectations in terms of what they're supposed to do with your data. That is, who it can be shared with, used, in other words, people who need it to do their job, and only the people who need it to do their job, and then it should be used for the benefit of your company and not used for any other purpose. Number 6, get the right persons under a confidentiality agreement, which can also be called a confidentiality covenant. Those are enforceable in Tennessee to the extent your data is legitimately confidential information and corresponds to our trade secret laws. So again, it's a good idea to get those signed at the beginning of employment, but you can get them signed during employment. Once you figure out what your confidential information is and who really has access to it, then put them under a confidentiality agreement. Number 7, in your confidentiality agreement or your other employment documents, provide that when an employee leaves your company, that they have to give you back your confidential data, all of it, along with your computers and the devices you've provided, and that they're not supposed to take any of it with them or keep any of it. And then they should certify as they're leaving that they don't have any of your confidential data. Number 8, enforce your rules where there's non-compliance. Follow up on it. So build a culture where people understand your confidential data is important and that they have to follow your rules. Number 9, at the last meeting you have the employee, or close to the last meeting when they're exiting, cover what the employee's obligations are in terms of your confidential data, and that you expect for it to all be returned along with the other computers or devices or anything else they have that belongs to you. Or if you don't have a final meeting, or if you're worried that the employee didn't get the message, then you can send them a post-employment letter that reminds them of their obligations as it relates to your confidential data. It also doesn't hurt to see if, as part of an employee who's departing, if there's any evidence of data theft when someone leaves. For instance, it's not that hard to just check their email or their computer and see if there's been any downloads or any emails that have been sent outside your system containing your data. You would be amazed at what people do when their employment is ending and what they think they can take. So you just never know, no matter who the employee is. Then number 10, when valuable information is taken or misused, make a demand and address it. And if the employee or ex-employee won't cooperate and provide adequate assurances that your rights are respected and your information protected, then sue them. It is pretty common litigation in Tennessee, most of the time in Chancery Court, and courts regularly enjoin bad conduct that involves the misappropriation of trade secrets and the breach of confidentiality agreements. So I hope these 10 points help you understand how to protect your confidential information in Tennessee.